Good morning, ladies and gentlemen. I'll call to order this hearing of August 31st, 2023 in the matter of case file Z0079-23-M, an appeal of that application. My name is Joe Turner. I am the county's hearings officer. I'll start with some brief announcements and a summary of the process that will follow so everyone understands how you can participate in the hearing today. I start by saying I am not a county employee. I am licensed as an attorney and trained as a planner. I serve under contract to the Board of Commissioners. I say that so you know you're getting a somewhat independent review of the application before me today. My role as a hearings officer is to conduct the hearing and make decisions about certain land use matters in Clackamas County. In making those decisions, I am required to apply the county's existing laws. I don't have the authority to vary from or change the laws. If you think that the laws need to be changed, you can work with County Planning Commission and Board of Commissioners to do that. But state law requires that this application be judged based on the laws in effect when the application was filed. As a hearings officer, I'm to provide an unbiased decision maker. I believe I am unbiased with regard to the application before me today. I've not had any pre-hearing contact with any of the parties regarding the substance of the application or appeal. And I don't have any interest in the subject property or any of the surrounding properties. But you have the right to challenge my impartiality, and you can do that when it's your opportunity to testify. Procedure will follow. I'll start by asking staff to summarize the planning director's decision, copies of which are available on the county's website. Then the applicant will have an opportunity to present their proposal and respond to the director's decision and the appeal. Then the applicant, if anybody else wants to testify in support of the application, then we do so. And then the appellant will have the opportunity to present their appeal, respond to the testimony from staff and the applicant. And if anybody else wants to testify about this application in opposition or with questions or concerns about this application, once everyone's had an initial opportunity to testify, I will give staff and the applicant alone an opportunity to respond to the testimony that was offered. If those responses include any new evidence, I will give everyone a chance to respond to the new evidence. Otherwise, I'll close the public portion of the hearing and announce what I'm going to do. Generally, I will issue a written decision within about 2 weeks after the close of the public record. I'll send my decision to the county, and the county will send it to parties of record. So anybody who testifies orally or in writing before the close of the hearing will be sure to receive a copy of my decision when it's issued. If you choose not to testify but still want to receive a copy of the decision, you can contact county staff, Ms. Dance, and ask her to send you a copy as well. Anyone with an interest in this application may offer relevant oral or written testimony. But testimony should be relevant to the applicable approval criteria, which are set out in the director's decision. Also, it's important that all parties make their best case to me. My decisions are final for purposes of the county, but may be appealed to the Land Use Board of Appeals, or LUBA. However, LUBA generally will not allow new testimony and evidence on appeal. They'll decide any appeal based on the record before me. So if you feel it's important that myself or any future decision maker knows something about this application, you need to make sure it gets into the record before me. In order to preserve your right to appeal, you or someone expressly representing you must testify orally or in writing before the close of the record. And in order to raise an issue on appeal, someone must have raised that issue before me with enough specificity that people can understand what the issue is. And if the applicant wants to object to any conditions of approval on constitutional grounds, they must raise those issues before me as well. In order to preserve, no, I just said that, sorry. If you feel you need more time to prepare, you can ask me to hold the record open or continue the hearing. If I hold the record open, you'll have an opportunity to submit additional written testimony and evidence before I make a decision. If I continue the hearing, we can come back and do this again at a later date. Whether or not the hearing is continued or the record is held open for any other purpose, state law requires that I hold the record open for an additional week for the applicant alone to submit a final written argument without any new evidence. The applicant can waive that right if they choose, but if anybody else wants me to hold the record open or continue the hearing for any other purpose, you must make that request before the close of the hearing today. Also, my decisions must comply with state law that requires that I issue a final written decision within 150 days after the application was filed. So there's some limit to how long I can continue the hearing or hold the record open. When you testify, please begin your testimony by stating your name and your full mailing address. Please spell your last name so I get it right. And if you represent someone else, please say so. As I noted, testimony should be relevant to the applicable approval criteria in the staff report. Also, please don't repeat testimony offered by yourself or earlier witnesses. Repeating your testimony doesn't make your case any stronger. The only issue before me is whether the application does or does not comply with the approval criteria. It's not a popularity contest, so whether everybody loves it or everybody hates it is not an issue I get to consider. But that concludes my introduction. I see a raised hand from Mr. Ed Christensen. Mr. Christensen, if you have a question about the process, go ahead and unmute yourself. Otherwise, if you just want to testify, I'd ask you to hold. Thank you. Hold that for until we get to that point. Ms. Dance will summarize the process for how the how you can participate electronically. So Ms. Dance, you want to go ahead and do that and then do your summary of your staff report or decision.
Okay, will do. Thank you for that, Joe. I'm going to do screen share and just have the first page of the PowerPoint with contact information up. Let me know if everybody can see. Hold on. There's a bunch of trees right now.
That's what we're seeing. Yep, now we got it.
Okay, great. I'm going to read just the script that kind of outlines rules and guidelines for the hearing today. This public hearing will be conducted virtually using the Zoom platform. Panelists for today's hearings, which include the hearings officer, county staff, the applicant, and appellant, have both audio and video capability. Audience members who have joined the meeting will have their mics muted unless they wish to testify, in which case they will be called upon to do so by the county staff moderator. Audience members' videos will not be turned on at any time. Today's hearing is being recorded as required by law. The county will make every effort to post the recording on the county's website later today. There is a designated time during the hearing when it will be open for testimony. The hearings officer will make it clear when this is. If you want to provide testimony, you will utilize the raise hand feature. Attendees on PCs and iPads, you have a raise hand button in the Zoom bar at the top or bottom of on the top and bottom of your screen, depending on your device. When the moderator switches you over to provide testimony, your screen will look different for a little while. Primarily, you will see all participants' cameras, not just the one who is speaking. Staff will call upon you when it is time for you to provide testimony. Be sure to provide your name, mailing address when you begin. Once you have provided your testimony, your mic will be muted and your screen will be returned to normal. If the record is open at the end of this hearing and you wish to submit additional testimony, email written testimony to me, Lisbeth Dance, at ldance@clackamas.us, or mail it to Clackamas County Planning and Zoning Division, 150 Beaver Creek Road, Oregon City, Oregon. Available on our webpage where you found the Zoom link for today's hearing. Testimony must be received by 4 p.m. at the end of the day the record closes. That would be today if the record isn't left open, and then if there's an open record period, we'll discuss that later. People who testify and provide their mailing address will receive a copy of the hearings officer written decision. If you do not wish to testify but would like to receive the decision, you must provide your email or standard mailing address by emailing it to myself or by entering it in the Zoom chat function during this hearing. Okay, that's just kind of the overall standards. I'm going to go into just the presentation for today, and then we'll go from there. I'm Lisbeth Dance, Clackamas County Planning and Zoning Planner 2. I'm the planner who reviewed the application for marijuana concentrate processing in the Ag 4 zone. This property is located at 32500 Southeast Rainbow Road. It is in the Ag Forest Zone. It's approximately 12.27 acres. The applicant's proposal for marijuana concentrate processing in conjunction with farm use as defined in our zoning and development ordinance is a primary allowed use in the zone associated with farm crop production. Marijuana production request has been submitted, reviewed, and approved under a different land use case file Z0080-23. The criteria for a processing facility in a resource zone outline criteria from the Ag Forest zoning, which is in 407, but by reference links it to the EFU zoning standards. The base standards for a processing facility for any farm crop include that 25% of the processed product be produced on the property. The processing facility is completely located within one or more completely enclosed buildings. The floor area cannot be more than 10,000 square feet to processing floor. That does not include area related to storage and preparation and other farm uses. The specific standards associated with marijuana processing limit it to concentrate only. They require that the property be at least 10 acres in size. They require a setback of 100 feet from all property lines for the processing facility. The ZDO 841 outlines standards related to lighting, odor, noise, security, waste, fencing for a processing facility to be operated in conjunction with farm use for marijuana specifically. Water is required to be verified and provided by a legal source. The application as submitted through completeness review included compliance with all of these items. This is a zoning map identifying the location of the property in the Ag Forest zone and surrounding zonings. Just to verify that the resource zones, the primary use in these zones is farming, whereas in residential zones, farming and residential uses have a priority. The closest residential zoning to this property is over 2.5 miles away. Here's an aerial image of the property. This is our 12-acre piece of land here. North is at an angle up. I apologize, I couldn't get it oriented straight up. The production and processing area is on this front portion of the property. There is no proposed production or processing on this back portion of the property. Here's the site plan provided with the submittal after several revisions for completeness that shows the larger 12,000 square foot production and processing building, and then additional production buildings, greenhouses. This is a detailed floor plan. The labeling on the plan say extraction, concentrate processing is the only type of processing allowed for marijuana in this zone. Other farm crops can be processed in other ways. However, marijuana is very limited to concentrate only, meaning no high heat, no high pressure. As proposed, the applicant has several washing machines, a rosin press, a dehydrator, and an ice machine. No high heat, no high pressure identified in the processing facility as proposed. In addition, there is a kitchen, and then in that conversation, edible processing is also allowed per the ZDO. That has not been requested in this application, however. Here are the elevation drawings of the larger 12,000 square foot building with a small area with a portion of it to be used for concentrate processing. As you can see, the building has no windows, it has doors. And then so you have all the elevations here, and then there's kind of a cutaway. And this is going to be the production area here, and then there's a large hallway separating the production facility from the processing facility. The appeal submitted includes a basis on the fact that conditions regarding odor and noise cannot be moved to prior to establishing use. ZDO 84103 requires an engineered acoustical assessment standards of what those are, as well as 84103F includes standards for review for noise assessments. These standards are clear and objective in the zoning code as they come from the section associated with production as well. Production is a type 1 land use application that is clear and standard in nature. and the standards for odor and noise in both production and processing are the same. In summary, county staff proposes that in summary, county staff finds that the proposed concentrate processing facility as conditions meets standards outlined in the zoning code and supports its decision of approval. That concludes our presentation. I can just keep the kind of contact information screen up, or if there's another image anybody would like to have, let me know.
Okay. I have a couple of questions. In your summary of the procedures, did you say the record would be open until 4 o'clock today, regardless of whether for submittal of written testimony?
I believe so. Is that wrong?
I do this in a number of jurisdictions, and I'm having trouble keeping it straight off the top of my head. That may be what Clackamas County does, and I appreciate the heads up.
Okay. And just FYI, 2 things. I didn't say, I apologize. Yesterday, the appellant provided additional testimony and kind of a written letter to the hearings officer. I was able to get that forwarded to the hearings officer and the applicant yesterday afternoon and this morning. And then when the meeting started just a moment ago, I did receive an email from the applicant with the engineered odor and noise assessments. Obviously, because we have been in this meeting, I have not had time to review them or look at them. I can share them through this meeting if we would like, and also they will obviously be added to the record.
Okay.
But they just came in a few moments ago, so obviously I have no idea what they look like.
I did, yeah, I did receive the appellant's letter yesterday, and I did have a chance to review that. I haven't had a chance to review the other stuff either, obviously. I had a question on page 10 of your staff report. It says no extraction is allowed in the EFU zone. I assume because the ag forest incorporates the EFU regulations, it's also not allowed in the ag forest.
Yeah, and that's specifically marijuana. Any other farm crop, lavender, hemp, any other farm crop extraction would be allowed. It's specifically a standard associated with marijuana that the extraction is not allowed.
Thank you. Page 14, let me find it real quick. On the bottom of page 14, the findings there in italic says the water will be provided by water provided for the non-irrigation season. I'm not sure what that means.
That's kind of a conversation that addresses water rights typically. Let me see.
I understand they're going to haul water with because
and so
harvest rainwater, etc. But
the proposal is to have water provided with this water reclamation system. As we all know, the world isn't always the same, and we could have extended drought periods, and so water reclamation isn't always might not be all. You might use all your reclaimed water at some point in time, and so to do that, there needs to be a backup of a water trucking company. I think that might just be an error. I didn't see that. It's on the bottom of page 4.
On page 14, the last part of the italicized before the bold that this criterion can be met.
Oh, that's a typo. I
apologize. Okay, so the non-irrigation season should just be deleted.
Yeah, that's a remnant from water rights. Sometimes have irrigation and non-irrigation seasons. And
not a problem. Done that same thing. And then the last question I had about the staff report, the staff report notes that they're proposing ice and water extraction. I thought they also mentioned the use of alcohol, ethanol concentrate, and that the code allows that.
I didn't see that in the proposal.
When I went back and looked for it, I couldn't find it. But
my
question is more: isn't that allowed?
It would be. So closed system ethanol extraction would be allowed. It's anything that has high heat, high pressure would not be.
Right.
But in the definition of concentrate processing, ethanol extraction is one of the allowed uses.
So they wouldn't.
They would be precluded
additional
from
county
doing
review
that
if they decided to use that process.
Right.
Okay, that's what I understood from the code. Just wanted to check.
Yeah.
Regarding the appeal issues, their letter, the appellant's letter focused on odor and noise, but they also raised issues with the fact that the applicant doesn't have a processor license. Can staff address that?
So marijuana Clackamas County does not issue licenses for marijuana production or processing. We are a piece of a puzzle that is required. The licenses and marijuana production and processing are issued by the OLCC. Land use is required for an application to be submitted to the OLCC for licensing. And so land use is the first step in a process of a property owner to get a use established. And so the licenses have not been issued because they haven't established, I believe, and this is maybe the OLCC requires buildings to be built and functions to be happening before they could do anything. So before they could get a processing license, they would need to be actually growing marijuana on the property. Before they would do that, they would need to establish their facilities. We're just kind of a piece. We're not the licensing or overseeing body.
I understand. Just wanted to address that issue. And then waste management, the appellant notes that there's no receptacle proposed, but I understand they're proposing waste management inside the building.
Yeah, that's my understanding. It'll be inside the building, and the OLCC has very specific standards in how waste is. Like there's, waste that you have as a person who's somewhere, and then there's waste for the use, and the marijuana waste is very closely monitored and has to be disposed of in a very specific way based on OLCC rules and guidelines.
Okay, thank you. That was the only questions I had at this point. Is the applicant here represented?
I believe so.
We are.
There we go. And your name, sir?
My name is Trey Burns. And actually, the applicant is Ed Christensen, who is also on the line.
Okay.
Okay, I'm moving Ed over as a panelist.
Thank you, Darcy.
And whoever wants, oh, is he still being moved? I don't see him yet. Maybe
I see him on my screen.
there he is. Mr. Christensen, if you're testifying, you're still muted. Or Mr. Burns, whoever wants to testify on behalf of the applicant.
So we've been through the process for.
Can I get your name for the record, please?
Okay, it's Edward Christensen, 25260 Southwest Parkway Avenue, Suite G, Wilsonville, Oregon, representing the client through Welkin Engineering PC. We've been through the process with the county for a long time, and we've worked through all the issues. We the noise and odor issues are deferred submittals to the building department, because basically it's very hard for planning departments to justify technical issues like that. So it's been the process for Clackamas County to defer these to the building department for evaluation, and planning department just literally conditions it that way. So we've met all the criteria for approval. We have been approved under the criteria. This is an allowed use in the EFU. We're meeting all the standards of the county, which are quite stringent. And we don't believe that the appeal should be rendered against this property.
Thank you, Mr. Christensen. You noted that it's an allowed use in the EFU. It's also an allowed use in the ag forest, which is what this property is zoned. I think that's what you meant to say.
Yes.
Okay. The appellant has raised issues that alleges that you have to show that it's feasible to meet this noise and odor standards of the county. And do you want to address that specific argument?
Trey, do you want to speak to that?
Yeah, I can do that. Trey Burns.
Thank you.
We have, compressed our timeline on our noise study and odor control plan. And we actually just submitted those this morning. But both of them show that the requirements will be met at the property lines. and actually above and beyond the requirements.
Okay, thank you. So today's submittal did include a noise study and an odor study, or a odor, the engineering for the odor system, I guess is.
Yes, sir.
Okay,
And to clarify, the odor and noise assessments are required by the land use decision, and they are reviewed for compliance with the zoning code clear and objective standards in 84103, I think it's G and F. And so when those reports are submitted, planning staff reviews them, goes through the code criteria, and assures that they are meeting the criteria as outlined in the zoning code prior to moving forward. The next step would be which would be building permit issuance.
thank you. Is there anybody else who'd like to testify in support of this application? If so, please raise your hand now by clicking on the raise your hand button. Yes, sir. Mr. Flynn.
Yes, my name is Jay Flint, representing the applicant. I just wanted to state for the record that the applicant does have a producer and processor license at other locations. And so once we go through this process of approval for this site and it's approved to relocate those, then we'll go through the OLCC process to relocate those 2 licenses to this location.
Thank you, sir. Is there anybody else who'd like to say anything about this application? Raise your hand by clicking on the raise your hand icon. So I am not seeing any. Oh, there we go, Mr. Burns.
Yes. So we did read through all of the letters and the comments and the concerns, and I feel like we've addressed the majority of those security wise, but then also water runoff. We should, at the end of this process, be completely off the water grid, with, of course, a plan B of hauling water in. We have double layer odor protection as well as noise. So I feel like the clients have really gone above and beyond to address some of the concerns, even beyond what's required by the code.
You're proposing a restroom and kitchen for the employees. Where's the water for that coming from? Is that?
Those actually, we're allowed, per the water master, we're allowed to take up to 5,000 gallons, I believe.
So it's
a
existing
day.
well that serves the residents on the site?
Exactly.
Okay.
So, and that'll be used only for toiletries, basically.
Okay.
The rest of the facility is completely on rainwater capture.
Okay, that's what I assumed. Just wanted to clarify that. Anybody else want to say anything in support? Michael. And I'll ask everybody who's not testifying to mute yourself. We got a little bit of feedback for a minute there. I thought Michael Morgan had their hand raised and then they went away completely. I'm not sure. Okay, I'm not seeing anybody else who wants to testify. Oh, there we go. Mr. Morgan back and his hand is raised. Can we unmute Mr. Morgan? I think you'll need to unmute yourself, Mr. Morgan. There you go.
My testimony is not in support.
Okay, we'll come back to you then after the appellant, Mr. Stamp, has an opportunity to present their appeal. So I'll come back to opposition or questions or concerns after the applicant, or excuse me, appellant, Mr. Stamp, has testified.
Yeah, can you hear me, Joe?
Mr. Stamp?
Yes.
Yes, I can. Go ahead whenever you're ready, Mr. Stamp. Now I'm not hearing you. I don't know if you've muted yourself, but we're not hearing you at the moment. Still nothing. I don't know if you clicked on something. Nothing yet. Mr. Stamp, you want to try logging off and logging back in and see if that works? Because we're not hearing anything yet. His icon just went away, so I'm assuming he's doing just that. So we'll give him a minute to log back in and hopefully be able to hear him.
Joe, in this moment, would you like me just to forward you an email the odor and noise assessments, or should I just add them as exhibits?
You can go ahead and add them as exhibits. That'll have the exhibit number. I'm going to hold the record open because those came in last minute. Everybody's going to want a chance to review and respond. So,
Okay.
is Mr. Stamp back yet? There we go. Mr. Stamp, you're back. You looks like you're unmuted now.
The
Never hear you.
internet gremlins are out to get me today.
You're not the only one.
Yeah. So anyway, that's frustrating.
Can I
Anyway,
get your name and address for and who you're representing?
my name's Andrew Stamp. I'm a lawyer at Val Fotheringham. Our address is 17355 Southwest Boones Ferry Road, Suite A, Lake Oswego, Oregon 97035. Here representing the appellants in this case, including William and Jocelyn Johnson. So obviously, we had new information come in right at the last minute. I'm going to need at least 30 days to review that, in part because I'm going on vacation starting tomorrow, and I need to be able to have my noise engineer review these documents. So that's my first request, is you hold the record open for 30 days. Evidence like that should be in the record at least 20 days prior. That's why we have a 20-day notice period. In any event, that evidence may moot out some of my concerns. My concern was without a noise study, there's no way to show that it's feasible to meet the noise criterion. I do disagree with staff that noise is a clear and objective criterion. I don't know how a noise analysis could ever be considered clear and objective under any circumstance, because it's inherently discretionary. And I would point you to the case that your former mentor and boss, Larry Epstein, was the hearings officer back on the Watts versus Clackamas County case. You may have worked on that, Mr. Turner.
I knew it sounded familiar.
Yeah. But any event, what that one was is that and I don't think this has changed in Clackamas County, but at the time you had a DBA standard, but it didn't say how you measured DBA, which in itself adds a layer of discretionary analysis to the equation. In that case, LUBA said that you have to use the LMAX standard instead of the L10 standard. And those produce vastly different results, because an L10 standard would require that you're only meeting the 50 dBA standard half of the time period, half of 10 minutes. So for 5 minutes or less, you're less than 50. Well, an Lmax standard means you don't have any spikes that go over L50, dBA. So that's an example of where, these are like traffic studies. There's a lot of little assumptions that go into things, where you measure things from. And so I just fundamentally disagree that that a noise study could ever be clear and objective. I also don't think that you should put noise studies in your land use code if you don't intend for the public to have some ability to review them. You could easily put the noise study requirement somewhere in, some other chapter of the code, but you put it in the zoning code and you made it a type 2 procedure, which means the public gets to review it. Otherwise, there's no point in even us being here. So anyway, some of that may be moot. That study that was submitted today may satisfy all of our concerns. But I don't know, because I haven't even seen it. In any event, I would also direct your attention to a case such as Butcher versus Washington County. That's a case that I did. And it was interesting. That was a kennel case, and there was a noise standard that wasn't much different than the one at issue here. It required you to comply with DEQ standards, if my memory serves me. but that's not, it's a measurement-based analysis. And the applicant didn't submit a study, but we submitted a study as the opponents. And the hearings officer relied on our study to show that it was feasible to meet the standard, which made absolutely no sense. She didn't really understand how to read a noise study, which goes, you know, that again points to the fact that noise studies can never be considered clear and objective. They're inherently discretionary. But the bottom line on that case is that LUBA said, yeah, the applicant didn't provide a noise study, and therefore the case has to be remanded. Similar result in Reynolds versus Clackamas County. It wasn't a noise study case, but there they said, well, we can see that the parking area will have negative impacts on neighbors, so we're going to add a condition of approval to say that that you're going to minimize any adverse impacts. Well, LUBA said, no, you've got to have a plan. You just can't have a condition to come up with a plan later. You need a plan as part of the land use hearing. So that's another case, you know, coming right from Clackamas County that shows kind of what I'm talking about. Another case that I draw your attention to is the Latter-day Saints case versus City of West Lynn. What's interesting about that case is it really shows how you get two noise engineers barking back and forth at each other and arguing about each other's studies, how much minutia you can get into very quickly with noise studies. That's the only reason I cite that case to you, because there's a lot of little nuanced issues that come into play. I went ahead just for fun in my letter yesterday and gave you a pretty good law review article on feasibility findings. I don't know that you need to read all those cases, but you might find it interesting because I collected the cases where feasibility findings were made and where LUBA found them adequate and where they weren't adequate. Mm-hmm. So you might find that something to put in your library. Might find it interesting. The odors. Oh, by the way, the last thing I want to say on noise, the standard requires you to show that it's 50 dBA at the property line. And if you know anything about noise studies, you know there's a whole lot of different assumptions that go into that analysis. And that's why it's not clear and objective. The odor study, I will say the county did a better job at trying to make those standards clear and objective. You know, it says you have to have a filtration system, and you have to maintain negative air pressure, and you have to keep it in working order. As much as I think they tried to make that clear and objective, it's not. There's lots of things you can argue about what it means to be in working order. That's an inherently discretionary standard. And also, maintaining negative air pressure is also the type of standard that has inherent factual and legal variables that come into play that would make that not clear and objective. All right, well, that's really, I mean, I think you addressed the issue, or the applicant addressed the issues with the processing license. I know that it is possible to relocate existing licenses. I recently went through that process. It's kind of a, you know, long drawn out thing, but it is certainly possible. So, and that's important because right now I don't think they're issuing any new licenses. So if you have one, that's great. But if you don't, you're kind of difficult. And I think if there's waste management inside the building, that would address that concern as well. So our main two issues, you know, I'd like you to address all the issues in the appeal, but I did hear some things today that would make me think that it is feasible to deal with those other issues. And with that, I won't belabor it anymore, but I would like to have 30 days I come back on the 18th, and hopefully by that time, our noise engineer will have had a chance to review those documents.
The 18th of September.
Yes, I'm going to be in the Wind River Range.
Yeah.
Diamond Mountains.
A little lack of cell service out there, I assume.
Yeah.
Okay. Thank you, Mr. Stamp. Is there anybody else who'd like to testify about this application in opposition or with questions or concerns? Please raise your hand now. I had one, but I don't see that raised hand anymore. So there we go. Mr. Morgan,
Yes.
go ahead.
Okay, I am Michael Morgan at 333 Northwest 9th Avenue, Unit 1014, Portland, Oregon 97209. And I'm concerned about the noise and odor as well. And that area, the Rainbow Road area, it's a pretty rural area, and I don't see any facilities, any businesses like this one being proposed in that area. So it seems that it would, change the area, would not fit in, and I'm afraid it would degrade the area and make it less desirable for people to live there. And that's all.
Okay, thank you, sir. This is considered a farm use under state law, and this is farm uses are allowed in the ag forest zone, so it is a permitted use. Although it is different than other uses in the area, this and other properties in the area could be used for a variety of agricultural processing activities, which are also allowed under the county code and state law. So while I understand those concerns, they're not relevant to the approval criteria. And as far as making the area less desirable to live in, residential uses are not a primary use in the ag forest or EFU zones. So those impacts to residential wouldn't be relevant to the approval criteria, even if this was a conditional use, which it's not, it's a permitted use. The only issue is whether it meets those specific criteria for a marijuana processing facility in the county code. So while I understand your concerns, they're not relevant to the applicable approval criteria. Is there anybody else who'd like to say anything about this application? Mr. Morgan, your hand's back up. You'll need to unmute yourself again. There we go.
I meant to say that the facility, it seems to be more like a factory than a farm.
I understand, but it is an allowed use. Other types of farm factories, processing of various types are allowed in the agricultural areas of the county under state law and the county code. William Johnston, you have your hand raised. You'll need to, there you go.
William Johnston, 33125 Southeast Rainbow Road. Based on the information that was put into appeal, we just feel that the county does have a responsibility with these facilities to provide an opportunity to ensure that these are clear and objective. And with the couple that Mr. Stamp has presented in the appeal on behalf of the community members of the George community, we feel that that is not the case. And I just wanted to make sure that I voiced that over, that there's a large community up here. Sorry, there's a large percentage of a small community population up here that essentially is under the same understanding. And I wanted to make sure that I voiced that as well. I'm not able to get on screen, but I'd showed my face if I could. I hope I appreciate the time, Mr. Turner, and the group to get together, and we're happy that we get the opportunity to sit in this appeal meeting.
Thank you, Mr. Johnston. Anybody else who'd like to say anything at all about this application or appeal? Mr. Johnson, if you click on the raise your hand button, so yours will go away. Terry Jackson. You'll need to unmute yourself. There you go. Oh, nope, your hand went away, but you're still muted. So I'm assuming you've decided not to testify. I have a
No,
panelist.
I'm there.
Oh.
I'm here.
There we go. Okay, thank you, Mr. Jackson.
That's confused here. Address is 32760 Southeast Rainbow Road. I believe the county has skewed the definition of what is a concentrate and what is not. I know that's the legal definition they're using. Every common definition on the internet has any liquid extraction is an extract, which is not allowed in our zone.
The
I
county
voiced my
code
opinion on
is the
this.
standard I have to apply, although the internet may have different definitions. The county has
Well,
defined it. And that's primarily, I'm assuming, because of the hazards, potential hazards with heat and pressure combined with the solvents that are used in those other processes that are
the
not.
applicant, oh, excuse me, the applicant also shows a vacuum oven in his drawings.
Mhm.
Would that not be considered heat and or pressure?
I will ask the applicant to explain what that is. I don't know. It's a good question. I will
Okay,
ask.
I saw that in his drawing.
Mhm.
It's heat and pressure, and it's alcohol, which is flammable, that can be used. And I totally disagree with the county's definition. Just putting that on record. And that's about all I have to say. Otherwise, we're on a dead end road up here. If they start a fire, we're all gonna die.
Right. Here we go. Get it spelled right. Thank you, sir. Okay. I'm not seeing any other raised hands, so we'll go back to the applicant, or excuse me, to county staff first, just in case staff have a response or want to leave it to the applicants. Up to you. Ms. Dance,
Thank you.
anything further from the county?
Yeah, thank you, Joe. This is Liz Dance, Clackamas County. I just wanted to have a few statements. I am unsure with the case is referenced by Andrew regarding the appeal and the odor and noise standards. The odor and noise standards associated with marijuana production were established in 2016. Those are the case files were definitely prior to them. In addition, I'm not sure if any of those case files are addressed in resource zones, whereas residential uses in residential zones might have a different standard than a resource zone for neighboring properties. And then to address some clarifying questions from surrounding property owners, the only processing in the resource zone that is limited to concentrate only is marijuana. If this farm were to be a lavender farm or a hemp farm or any other farm, they could process in any way as long as they met the base standards of size and space. So those are just the two responses to some of the information brought up at the hearing.
Okay. As far as the odor and noise standards, whether they're clear and objective or not, I think is not something I'm going to have to address in this proceeding because the applicant has submitted those studies. So I think it's
I
kind of
believe them to be clear and objective because they're the same standards in 84102, which is a type 1 application. Type 1 applications by nature in 1307 are clear and objective, and the only way a type 1 decision can be issued is if those clear and objective standards are met. And so because the standards are the same in 84102 as they are in 84103 related to odor and noise, the county represents that those are clear and objective standards.
Mr. Stamp may argue that your type 1 is wrong and would be subject to appeal, but that's and he's nodding. So but I as I noted, I don't believe that's going to be an issue I need to address, because if the applicant has submitted those, it will come down to whether those are adequate to demonstrate the standards are met. Thank you, Ms. Dance. Mr. Burns. You're muted, Mr. Burns.
That should work.
There we go.
So working backwards on the questions, a vacuum oven is basically used to remove the moisture from the plant. So it's not an oven a high pressure system. It's a low pressure vacuum to remove moisture from their product. And then to address Mr. Stamp's testimony there too, with respect to Mr. Stamp, I would request that we do not keep the record open for 30 days. We submitted the noise and odor study more as an addendum to a nicety, if you will, so that you can see that we're actually working on it. But as we understand the process, those aren't actually required until we go into the building permit process. And at which point, if they're found to be adequate, then we'll be able to move forward. If not, then we'll go back to the drawing table.
Okay. I have to hold the record open regardless. And I have a similar conflict. I'm going to be on vacation until 1st of October. So I wouldn't be able to get my decision out anyway. Is the applicant willing to extend the 150-day clock to accommodate that? Let me grab my calendar.
Just a FYI, the 150-day clock is October 5th.
Yeah, that's why I'm concerned. Because I come back on, I think, the 2nd of October. And I leave next soon. During the open, what would be during the open record period, so I wouldn't be able to get it out until I come back. Mr. Stamp, you come back when? You're back, you muted. You're still muted.
How about now?
There you go, there you go. You're
All right. September 18th is my first day back. So I'm only gone for 2 weeks, but.
there we go. And find the right today's date. If we held it open for 2 weeks, could you say until the 18th even? Well, what I'm wondering is, can your noise engineer submit their response, review and submit their response during the first, like a 2 week, maybe a little more than 2 week period, and then 2 weeks for response and a week at the closing?
I'm a little hesitant to agree to that. I mean, the applicant could have had this stuff in weeks ago. I mean,
I understand, but I cannot require the applicant to extend the 150-day clock. So I've also got that issue.
Now you can deny the application.
Yeah, that's true.
So I'd really minimum of 3 weeks for me, because literally I assume the day I get back, I'll only have a week to look at it and figure out.
If we could do 3 weeks and 1 week and 1 week, would that work? So
That would
generally
work.
what I do is hold it open for new evidence from anybody. I could do that for 3 weeks. Hold it open for an additional period for anybody to respond to whatever was submitted during that first period. That could be reduced to 1 week. And then a week for the applicant's final argument, which they could waive if they chose, which would get past my conflict when I'm out of town.
I'd agree to 3 weeks for that first open record
Okay.
period, and 7 days for the second one, and 7 for the final argument. They could reduce that as well.
Yeah. Does that work for you, Mr. Burns? Because that would accommodate I won't be able to get to this until I get back from vacation on the 2nd of October. And that would allow me time to do that.
Understood. Yes, that works for us.
Okay. Is the applicant willing to extend the 150-day clock
Yes.
to accommodate that? I want to get a specific date, October 5th. Would you extend it for 3 weeks until October 26th? I'm sure I can get it out sooner, but that would give me a buffer just in case.
Sure.
Okay, I appreciate that.
Of course.
I'll ask you to submit that in writing during the open record. Anything else from the applicant at this point?
Not at the moment.
Okay, in that case, I will close the hearing. I will do what I just said. I will hold the record open for 3 weeks until September 21st at 4 p.m. Anybody to submit additional written testimony and evidence. anything you want to submit has to be physically received by the county by 4:00 p.m. on the 21st of September. You can submit it to Ms. Dance. She'll forward it on to me. Then I will hold it open for a second period for 1 week until October 28th at 4 p.m. for anybody to
September 28th, right?
Thank you. September 28th at 4 p.m. for anybody to respond to whatever was submitted during the first week. That second period is limited to responses to anything submitted during the first period. And then until October 5th for final week for the applicant alone to submit a final written argument without any new evidence. Again, until 4 p.m. I will try and get my decision out by the 19th of October. I will definitely get it out by the 26th to accommodate the 150-day clock, but that just gives me a buffer in case something happens. So that's what I will do. And that concludes our hearing.
Mr. Turner,
Yes.
was that September 21st was the first period?
Yes, first period is the 21st of September. Second period,
What's close of business for Clackamas County?
4:00 p.m.
And it can be submitted by email?
Yeah, as long as it's received before 4. Got to account for any delays in the internet. And then the 28th for the second period, the 5th of October for the final argument.
And just so I understand, we're doing 3 weeks for any evidence to be submitted. And that goes to the 21st of September. We're doing 1 week for response only to all evidence submitted. That's 1 week that'll end on the 28th at 4 p.m. Then we're doing applicant only response for 1 week that'll close on the 5th of October.
Yes.
And then, but the
Yeah.
applicant can waive the final argument if they don't.
Yeah, or submit it early, whatever they want to do. Yeah, and I will I will start my decision as soon as I get notice that the record is closed.
And then we need a letter from the applicant requesting to extend or to toll the clock or just extend the clock another,
until October 26th.
Till October 26th. Okay.
Yeah.
Ms. Stantz, could you email or somehow make available the documents that were submitted today? Can you do that?
Yeah, I need to open them, label them, and put them in the exhibits, and then they'll be posted on the website as exhibits. I believe there'll be 28 and 29 or 27 and 28.
But that can happen today?
Yeah, that'll be happening after this meeting. I just wasn't able to
Thank
do
you. I
that last
appreciate
meeting.
that.
Okay. Thank you all. Have a good vacation, Mr. Stamp, and everyone else. Have a good afternoon, and that concludes our hearing.
All right.
Thank you.
Thank you.
Thank
Mr.
you.
Hearings Officer.